Welcome, everybody. There's Karen. Excellent. Can everybody hear me? And we have 197 people taking part.
It would seem that everybody can hear us.
Okay. Well, we're already getting questions streaming in, and I see Michelle says yes, so that's excellent. And everyone can see the attached PowerPoint slides? That's excellent. Well, we had 485 people register for today, and normally we get about half of that actually attending. Tomorrow at noon, we'll have this event done again, and we have 233 registered for tomorrow, so one presumes about half of that. And this won't be the only one. So last I counted, we had 250 questions. Oh, there are more than that now, plus the ones that come in this evening. But we're looking forward to all the questions. We're going to try to answer them by themes. Now, as you can see on this screen that you see here, Ask the Experts, these are the main themes you can see for the questions. And we have all sorts of, we've set up a recording of this. So everyone who registers will receive the recorded video and the PowerPoint slides. Now, I just thought I'd like to speak briefly. You can see here that I think as anyone who has attended a previous event like this, you can see that about 1 household in 10 in Ontario is a parent household of a child with special needs. And this is the simplistic breakdown of the types of disabilities. And as I've mentioned before, I don't see any category that would clearly identify such things as autism, but I'll ask the statisticians at ODSP if they can come up with some numbers that's a more detailed breakdown. Now, what we're going to do is we're going to walk through not the presentation that I always do, but we're going to talk about these things: benefit increases, disability and caregiver tax credits. These are all the questions you have from previous webcasts. How to qualify for increases, what the asset tests are. I'll speak briefly now about the caregiver benefit. If you have a child under 12 or a child over 12 or an elderly family member, and caring for them as a result of COVID reduces your income by 50% or more, then you can qualify for the $500 a week benefit. And it has now been extended. So it's not just 26 weeks from last September, it's carried on further than that. These are matters about the disability tax credit and the caregiver tax credit and RDSPs and how much they can accumulate to. The question of guardianships and powers of attorney. Diane Navarano will be answering those questions.
Ken, is there a way that you can speak a little louder for them?
Certainly. I've tested out this mic and I need to put a bit of gain on it. How's that? Is that better?
That's better for me, yeah.
Okay. So there are a lot of questions about guardianship. Now we'll be doing separate webcasts the next few months on guardianship and benefit increases and wills and trusts. So any questions you don't get answered on those particular topics in the next few months, we'll be answering them by more webcasts. I think that's enough of those slides. So we'll just leave this cover slide on here. And Karen, you're going to be answering questions in the background, typing in. So I'll just look at these questions that people have started with.
I'm going to try to get to as many as I can.
Yeah, I think you got, what, 150 last time in an hour and a quarter?
Yes.
I've read that a person on ODSP can own a car and a house. How does that work with minimum gift amounts? I trust people can see these questions. And it has nothing to do with the gift amount. You can have an exempt asset of a car or a house. The problem that arises with respect to the gifting is that if you own a home, can you afford to carry it? And if someone gives you money to allow you to afford to carry that, that does fall into the 10,000 over 12 month rule. Now, obviously, shelter, suitable housing, safe housing is a big issue because, of course, you can't live on the shelter component, the 496 of the 1169, and so it has to be subsidized in some way. And that does then fall into the 10,000 over 12 month rule, unless the party who is subsidizing, the parent typically, is either on the lease but doesn't live there, in which event they can pay the differential between your 500 of the 1,500 rent because they're on the lease, or if they're on the title of the property at least as to 1%, in which event they can help pay the excess costs because then all they're doing is paying for their own property. What is a reasonable compensation for co-trustees? Normally, if a bank trust is the trustee, the other trustee, the parent, the family member, typically isn't compensated, although they could be. Now, and that compensation can be any amount you wish. The bank trust company, if this trust is big enough for the bank to take it on, and basically, if your trust is not big enough for, say, $500,000, the bank trust company, even though you may nominate them, probably won't want to deal with this trust because the compensation that they receive is usually 1.5% thereabouts. And they're really not interested in less than at least $7,000 a year. There is one trust company that will take smaller trusts, Henson Trust, and their fee is 1% per year, or a minimum of 3,000, which would be 1% obviously on 300,000. If it's 200,000, that their annual fee is still 3,000. But at least you have a corporate trustee, which when you avail yourself of a corporate trustee, it means that you have no other alternatives really. Now, if you have a family member serving with the trust company, which is not uncommon, normally they're not compensated. They don't get part of the 1.5, but you could compensate them either by making provision in your will in the trust provisions that they'll be compensated to some degree, whatever that degree is, or you could keep in mind that perhaps they're going to get the residue of the trust. And you should also keep in mind that a trustee's fees are declarable as income and potentially taxable. In a parental will, can it be specified if the Henson Trust beneficiary passes away after the parent, then the surviving sibling can inherit the Henson Trust? This is the standard procedure. The trust residue provision in the trust provides normally that the residue of the trust goes either to the child of the beneficiary, if any, or to their siblings, or to the siblings' children, if any, and so on. In a few cases, it's perfectly doable. But in a few cases, we've had it set up where if there is a will that the beneficiary has prepared, then it can go pursuant to the terms of the beneficiary's will. But failing that, it goes pursuant to the direction of the testator, the parents who have died. I've just received notification from ODSP that my son will get just over 700 in benefits. He's not in the bracket that you had mentioned. We don't own or rent a home, but live with our mom, who should be my son's grandma. Why are we only expected to receive $760 for him? That's a very good question. I have no idea. The room and board amount is $896, so he should be at least receiving the room and board of $896. And in fact, you should chat with Karen, because if he can shop and cook, we can probably get the $896 increased to $1169. He would be contributing $550 to the household, and this would not be declared as rent. It's not rent. It's just a shared shelter cost. So I don't know what the reason would be. You'd have to send us the ODSP stub for us to take a look at it, because that's a very unusual amount. Now, if he's not living at home, then he might well be getting 1169 on the face of it, but the shelter component is 496. So if he's in a geared to income situation, then the rent may not be 496. It could be $135. So you take the 600 and something that is the difference between 496 and 1169, and tack on the RGI amount, and under certain circumstances you can see that that might add up to that number, 700 and something. I'm currently getting the tax credit. Once my child turns 18, does she have to do her own tax and get the credit? Once she turns 18, do I apply the caregiver tax credit? Well, this is a slightly confusing question, but once the child turns 18 and is receiving ODSP, well then yes, of course, they should file their own tax return. They won't pay taxes because they don't have taxable income, but they would file the tax return and they would receive about $900 in various benefits, Trillium and this and that. But they don't pay taxes, so they can't use either the disability, or they can't use a disability tax credit. So it is normally transferred to a tax-paying parent or family member. And the caregiver credit is the credit of the parent or family member, so the child can't use the caregiver credit. And yes, you should use that. It's on line 30425 or 30450 in the 18th year. It doesn't matter if the child's birthday is December 30th, it's still in the 18th. How's the sound these days, Karen? Is it picking up all right?
Yeah, for me, it's not bad, but if anybody's having a difficult time, down at the bottom of the Zoom next to the mute, there's an arrow that goes up.
Yeah.
They can just adjust their audio settings there.
Okay.
You have a little bit of a crackiness, like maybe your mic's loose or something.
Okay. The reason I'm asking these questions is that I've just used a new glorified mic that I thought would be a better sound for people, but apparently it's not as great as it was expected. Is there any chance that ODSP may increase anytime soon? No. What we've seen recently over the years is that every second year or so, there's some modest increase in either the shelter component or the supplementary benefits. Hello, Rachel. In a parental will, is it sufficient to simply state the disabled child's portion of the estate will go into a trust with a named trustee allowed to use absolute discretion and not explicitly state Henson Trust? How important is it to use the term Henson Trust? It's not at all important to use the term Henson Trust. It's not the name of it that does the magic. It's the clauses, the provisions in the trust that provide absolute discretion and the non-vesting of the asset and the rebuttal of the even-handed rule and certain other things. So I see, Suzanne, you think I'm speaking too quickly. Well, I'm trying to get through a lot of questions. Can you explain in more detail what the Henson Trust is? Well, let's go to that slide. This is the wording, the essential elements that goes into a Henson Trust. Now, of course, we say Henson Trust, just so that people are clear. I rarely see those words in any other of the wills that I review. Of course, we review them every day. But that's one of the basic questions. You know, people say, well, I'm unsure if I have a Henson Trust. And that's part of the reason. They're just, it's not flagged clearly for them. But these are the things to look for: absolute and unfettered discretion, shall not vest, and a rebuttal of the even-handed will. So people are still having trouble hearing me. I'll try this, and we'll have to experiment further with pickup on this thing. I'll try to talk a little louder and get a little closer. If the ODSP application was late due to certain circumstances, Do I get paid in retroactive? No, I don't. You don't get anything retroactive. My son has an RDSP. Should I add my daughter onto it so that she can look after it once I'm no longer able to look after it? Well, Gil, she could be an account holder, but she would have to either be attorney for property, or if your son's not competent, a legal guardian appointed with you to be the account holder, because otherwise only a parent can be an account holder. It's the gain on the mic here that I'm thinking is the problem. It's still muted.
No, Karen is, so if we go like this. You have this on, which is great.
We're just trying to correct the sound here.
I've suppressed the background noise. Is that?
Yeah.
Maybe this will be better.
Sure.
Okay.
Okay.
Try that.
Let's see what happens. Thanks, Dan. How do you add someone onto the RDSP? Well, if the person is competent, if the beneficiary of the RDSP is competent, they can sign a power of attorney, or they can give a consent. But if they're not competent, then as I say, you have to apply for legal guardianship to have a legal guardian who then could manage the RDSP. How do I get legal guardianship? That's a very good question. Well, powers of attorney are better if the child is reasonably competent, or if you think in practice that banks and doctors for medical care and the RDSP managers, if you think that they'll hang their hat on a power of attorney because the child is competent, well, then that's the cheaper process. But otherwise, you have to apply to the court. The whole thing costs about $8,000, so we don't try to promote it unless it's necessary. But of course, what happens is when a parent reaches a certain age, they realize that they're not old, but they understand mortality. And the problem is that RDSPs, if you start investing these RDSPs when the child is 18, for example, if you invest it starting at age 18, and you make your annual $1,500 contributions, and you've invested it properly with proper advice, and you earn 5% a year, which is doable even in today's world, then by the time the child's 60, it's about $700,000. So the problem is that under the present rules, only the parents can be the account holders for the plan if the child is not competent. The child is, as I've just said twice, if the child is competent, then they could sign a power of attorney and allow people to be the account holders. But this is a lot of money, and somebody has to manage the investments. So if the parents pass on, who will be the account holder? And when the money starts to be paid out at age 60, it pays out about $30,000 a year on this basis. Who's going to manage that money? Because the checks, the payments are going to be made payable to the name of the child. So it's a big issue. And what happens in practice, we do a lot of guardianships. What happens in practice is that at a certain age, the parent decides that now is the time. And that varies. We're doing one now that we're just starting next week, where the child has just turned 18. And that's not uncommon. But often the ones at that age are motivated by a health issue or some other major issue. This one is just preparedness, readiness, so that if something happens, the parents know that this is in place, that the two sisters who are in their mid-20s, who will be guardians with the parents, that they're there, that it's all done. And it's not something left to the children after the fact. So that's the main motivation. And what happens really is the parents decide at what age they think they want to do this. I've only had one case where the parent simply could not afford this, which is that happens, obviously. And so it was decided that she would not proceed with this. She would leave it so that after she's gone, the trustees would pay for this from the trust. And that's just a practicality. A question here about ODSP and CPP disability. And what happens is if you apply for ODSP and you were employed and you did contribute to CPP in 4 of the last 6 years, then you could perhaps apply and receive CPP disability. But in my experience, well, for a fact, the test for CPP disability is that you can't work at all. And that's buttressed by the fact that if you do succeed in getting CPP disability, you can't have employment income of more than $5,000 a year. You can make a small amount now, used to be less. And in my experience, CPP disability is always less than the maximum amount of ODSP. And ODSP, the test, simplest test, is can't function in a competitive workplace, which is a lot easier than can't work at all. And if you do get CPP disability, which if you could apply, if you would fall into that box, ODSP will oblige you to apply for it. It's very difficult to be approved, but if you did get approved, then the amount of CPP disability that you received would be simply set off against ODSP, so you'd be no better off. Once you have a Henson Trust in place, hi Tula. Once you have a Henson Trust in place, how often must you renew or update? A lot of our paper is good for 15 to 20 years. You know, it contemplates lots of different possibilities. That said, there's circumstances where if you do this work when the child is young and the siblings are young, you can plan ahead, certainly, but sometimes things happen. The brother, your brother, the uncle that you had appointed as a trustee if you die predeceases you. And the children are still too young to effectively be trustees. So, okay, then you have to update or amend the will. And sometimes there are other unfortunate circumstances or very fortunate circumstances that indicate that you should make a change. You know, your parent, an unfortunate example would be that a parent, your parent, grandparent of the child passes on, and then you happen to inherit a sizable amount which you hadn't expected. Well, perhaps this amends how you divide the estate, for example. If someone already benefits from a testamentary trust and another relative wants to give them an inheritance, can the existing Henson Trust be added to in another will? Yes. It can receive from a death. It wouldn't be wise, I won't go into the details, but you wouldn't normally make a living contribution to a testamentary trust, although you could. That would take some discussion. But if someone predeceases you and sets up a trust, say you have a sister, she has a child, the child has disabilities, and the mother, your sister, dies. And then you, his aunt, never married, no kids, decides that you want to leave a share of your estate for the child. Well, you could leave it to the trust created by your sister in her will. What happens a lot is you consider, for various reasons, if your parent, the grandparent, were to pass on, once you've got your own affairs in place and you understand how it works, then you might consider having your parent, the grandparent, leave the share that they're going to leave for you, whatever it may be, instead of them leaving it to you directly so that it's invested and the income is taxed. You might suggest to them having a Henson Trust in their will for your share. And you would be the trustee of this trust. You'd also be a beneficiary, so you can draw the capital, not a problem at all. but you would also perhaps have the child named as a beneficiary so that the income that is generated by this trust set up by the grandmother, the income could be attributed to the child. And if the child has just their personal tax credits and the disability credit, they have about $21,000 of personal tax credits. So the first $21,000 of income from this trust attributed to the child, not given necessarily, would be not taxed. Now, this is better than even being taxed at 22% at the lowest rate, right? Not being taxed is much better. And in my experience, parents, especially astute investment parents, are very keen on this idea because they have no interest in the income generated by the money that they have worked for and saved and not spent and held for their family, their child and grandchild, to have a 22% or 33% or 44% of the income paid to the government. They have no interest at all. Now, it is true that sometimes they're prepared to have Henson Trusts put in their wills if the child, the mother of the child with disabilities, pays the fees. Other times they're quite happy to pay the fees because they know that this is the best thing to do. What does it mean with life insurance to fund trusts? It's very straightforward. For example, if you have two parents that have a child with disabilities, perhaps they have a modest income, perhaps they don't. A modest estate, perhaps they don't. Then what they could do, for example, very economically, is buy a joint and last policy, permanent, whole life, whatever, joint and last policy that pays on the second death. The premiums would be slightly less because there's two insured parties and one will live longer, but it's still, relatively speaking, based upon the wife's life normally. But it is a lower premium. And what it does is on the second death, that could be specifically earmarked to go to the trust for the child in the trust that is contained in the will of the second to die. It's quite economical. When does a Henson Trust start? When both parents pass away? Yes, typically when the second parent passes away. There's a common misconception that we have to disabuse people of, that somehow once they've signed their will, that the trust provisions inside the will have created a trust. Well, that's not true. It's been structured, but of course it's not funded until someone dies. So there's no administration, there's no fees, there's no filings, there's nothing to do. My daughter has guardianship of my son. Does she need power of attorney too? No, Gail. If someone has guardianship, it means that the son is not competent. So therefore they can't sign a power of attorney. Can you review the circumstances which are required to increase the ODSP benefit to $11.69? It's quite straightforward in a sense. The 896 is the room and board, and we break that out by doing a lease type document between the parent and the child, providing the child will pay $5.50 a month shelter costs. And this is not rent for the purposes of the parent. So you don't declare it, nothing changes. Similarly, the child can't use it as rent on their tax return as you would otherwise, perhaps. And that takes care of the room part of the room and board. And then it's a question of, can the child shop and cook? To what extent? And so it's a question of, well, if you went with the child to the grocery store and the child had a shopping list, even a picture list, could they pick those things out and fill the cart? Could they take it to the cash? Could they tap to pay? And when you went home together and took the groceries into the house, would they know where to put things? Would they know where to put them in the cupboard or the fridge? And of course, for many children, when we do this, they're young adults, and when your young adult child is either living with you or comes home to stay with you, they don't shop and cook, do they? If you're lucky, they might order in a pizza for you, but that's just how it is. But with kids with special needs, it's even less likely, obviously, in a lot of cases, not all. So it's a question of if they did shop and if they could could they make simple things with a microwave? Could they use a convection oven? Possibly, could they use a stove? Could they learn to use a stove? It's like that. So there's a process to it. And I can tell you that ODSP has a lot of sort of trick questions that they try to use when the parents, because we're quite open and transparent about this. This is how you do it. So, you know, if you want to try yourself, do it, go for it. The problem is that the ODSP doesn't have this strong aversion for parents getting the benefit increase themselves. They just don't want that kind of word to get around. Now, obviously, we're typically successful. You know, if the child is just not going to be able to succeed, of course, then we don't apply. But our fees are contingent on success, which is a pretty fair deal. And you know, it increases benefits by $273 a month. So we're open to payment plans. But otherwise, that's how you do it. You have a document and you make arrangements for the child to shop and cook themselves. Can money from the RDSP start to be taken out before age 60? If so, is there any time where clawbacks of the government funds do not apply? Well, it's a simple kind of equation in a way. If you start when the child's 18, and there's a 10-year vesting period for the grants and bonds, well then obviously, if you contribute for 20 years, then you stop contributing because you don't get any more grants and bonds. And the grants and bonds have been contributed for 20 years. But then you have to have another full 10-year period for everything to be vested. Because people often say, well, the first 10 years are now vested. Can I take that out? And no, it's last in, first out. So if you contribute in the 20th year, you could withdraw, but depending upon how much you take out, it's a 1-to-3 ratio. For every dollar you take out, $3 of the non-vested grants and bonds are lost back to the point of vesting. So if you can do your own calculation here. You can see that if in year 20, you take $1,000 out, the grants and bonds from year 20, which is 4,500, you lose 3,000 and so on. So it's last in, first out. I will seek, this is Tanya, I'll seek guardianship when my child turns 18 in 1 year. Can I name my other child who is 16 as guardian as well? No, you'd have to wait till they're 18. Now you could add them on later if you wish, but I don't think you're going to need guardianship once they turn 18, because in practice, you can be the ODSP account holder, no problem. If they're not competent, as guardianship would indicate, you can be the RDSP account holder. And unless there's serious medical issues and you're just not getting the cooperation that you need, then you are the substitute decision maker, although that doesn't give you the clout that you would need in serious situations. So what happens is, what you're planning for more than today, most times, is the future. So what happens when you're gone? Who will be there then? Who will be the RDSP account holder? Who is going to get treated seriously dealing with medical issues? Who has standing? Who's going to handle the RDSP? If you happen to be a retired teacher, municipal employee, hydro worker, WSIB, OPP, those parties have statutory provincial pensions. And some of them are quite substantial. A teacher gets a good pension. Well, if they have a child with disabilities, and the same percentages, 1 in 10, apply to teachers and municipal employees and all of the others, then they have a pension when they retire, say $60,000. They have a spouse perhaps. So then let's say that it's a husband and he dies before his wife. So she gets about 2/3 of his pension. And then the mother dies, the wife. And if you have an adult dependent survivor child, well, then they stand to get 50% of that original pension. Well, if they're not competent, who's going to apply for it? It disqualifies the child from ODSP if it's greater than $11.69 a month, which a lot of OMERS pensions are not. And who's going to keep the investments of this money in hand? And who's going to manage it as it's paid out? Just as with the RDSP. When the child reaches 65, does ODSP end and they apply for CPP? Well, what happens is, in most cases, is the child approaches 65. Recently, what's happened is ODSP starts to send a letter to the benefit recipient in the year before they turn 65, telling them they have to apply for old age security and guaranteed income supplements. CPP obviously would only be paid if a person worked. Now, if they did, then of course, yes, they would certainly get CPP, but they would also get old age security and guaranteed income supplements, which would be offset. For every dollar of other income, such as CPP, you lose 50 cents of the guaranteed income supplements. Now, the OAS is about 7,000, and the maximum guaranteed income supplement is about 11. So that's 18,000. Maximum ODSP is 14,000. So on the face of it, you're better off either way once you turn 65. Key, my son was working 40 hours a week, good show. And since the pandemic, he has now only employed 2 days or 16 hours. He's currently getting EI benefits to subsidize his income. Do we need to submit his EI to ODSP? Yes. And unfortunately, EI is treated not as employment income, at least CRCB was treated as employment income, but true EI is more like a pension and is not treated as employment income where you get to keep the first 200 and for every $1 you lose 50 cents and so on. It's all treated as 100% offset. If your son, this is from Anonymous. If your son inherits 80 grand, you should give us a call. There's ways to protect it, keep benefits. How do we contact you? Well, that's easy. You send an email typically to Karen, or you go to the website, you fill in the family evaluation under the contact tab, and that comes to us immediately, and we take a look at it and give you an initial quick assessment of the situation and read your story. Our 18-year-old son with autism lives with us and will continue to do so. We've gone through the process with the courts and we have been granted guardianship. Good work. He receives $896 ODSP. We understand a portion can come to us as board and care, i.e. $400. Yeah, sure. Often the parent takes the whole thing and then just uses it for the child. We understand a portion, no, sorry. Can we take a portion of that and then put it into his RDSP? Yes, definitely. Or can we put a small amount of his ODSP directly? Yes. He is not capable of making his own meals. There's a growing account for his ODSP, just not sure what to do with it. So I see, so you're accumulating it. Well, you can let it accumulate up to 40,000. The personal asset test for him is 40,000. But normally what happens is it comes in and then either some, most, all of it is transferred out to the parent who provides the room and board and everything else. This is not income, by the way. do you determine reasonably competent enough to sign a power of attorney? Well, that's a question that we deal with every day. Because as powers of attorney, the document itself is a lot less expensive, obviously, than legal guardianship. And a lot of times, if the child understands, appreciates, if you can explain to them that this document allows you, mom and dad, to help them handle all of their affairs and to deal with their ODSP and to manage their RDSP and to help them if they need medical treatment. And if they comprehend this, which a lot of kids do, then I would say that they're competent enough for now. From there, you get to the practicalities of it. If you have this document signed, you can certainly submit it to Canada Revenue to allow you to file their tax returns. Canada Revenue won't try to peer past the veil to see, is this kid really competent? They don't care. They just want something to hang their hat on so you file the tax returns. But with respect to RDSPs, for example, the biggest thing, if you were to go with your child, or more to the point, you're gone, and the siblings, the sisters, go with your boy, because now they want to be the account holders on the RDSP. So they have this power of attorney, and they go to the bank and they want the bank to receive a notarial copy and to authorize them as account holders. When they go there with their brother, is the person they deal with going to look at the brother and talk to the brother and say, no, that he's not competent to sign these powers of attorney? Because that's the practicality of it. If people hang their hat on it and give you the cooperation that you need at any given time, you're good, as far as I'm concerned. But in a lot of cases, it's fine now. People cooperate more perhaps with the parents, but less so with the brothers and sisters when the parents are gone. What happens when the parents of the child are divorced and one parent sets up a trust? Fine, Christine, no problem at all. In lots of cases, each parent and perhaps the grandparents on each side set up Henson Trusts for the child. I've had situations where there was one child with disabilities, and the parents, at least with respect to the child, still have the same shared concern. That's not unusual. And I've had cases where we did the wills under separate retainers for each of the parents, and they've appointed each other as the first trustee. There's no conflict in that. But normally that's not how it works, of course. The trustees then become the brothers or sisters of each of these separated, divorced parties. And then perhaps if there's siblings, if you're fortunate enough to have siblings of your child that are old enough eventually to become a trustee, then that's more often what happens. There can be as many Henson Trusts as you want. One of the questions I've had over the years is, well, can you only have one, and how many can you have, and so on. But there's no limit. You could easily see that you could have one from a grandparent, one from each parent of the child, one from an aunt, never married, no kids. Any kind of family scenario you might want to look at. So here's a good one. So we have only one child with special needs and not competent. He has an RDSP. What happens when the parents die with his RDSP money? Is it still his? It's still his, correct? That is completely correct. There's often a misunderstanding that RDSPs are somehow like RESPs, which are set up and funded by the parent, which is what happens with RDSPs, of course. But the RDSP is the property of the not competent child. And what happens when the parents are gone is just as I've said, who's going to be the personal representative of the child to be the account holder? And then following on from that, next question is, well, what happens when the child dies? Well, the result, of course, is that since the child's not competent, they can't do a will. So it's what's called an intestacy. And then by succession law, the money that is in there is received by whoever is in the succession law tree. Now, of course, if the child predeceased the parents, it would go to the parents. But in this scenario, there are no siblings. So parents are deceased, no siblings, so they don't get it. If there were siblings, they would receive. And if they had predeceased but left children, then their child would receive. But otherwise, it goes up and down and over. And in most cases, it winds up in the hands of the cousins, the nieces and nephews of the aunts and uncles. And it may well be that these cousins have never come to visit this kid. So it seems a little inequitable there, but that's just how succession law works. My son is 19 and we opened an RDSP account and made a deposit of $1,000, but we got $1,000 only as a bond. Well, that's because it was in a year, he's 19, but you must have opened this up when he was younger than 18. Because if your household income is greater than $95,000 approximately, then the most that you get in recognition of $1,000 contribution is $1,000 bond. But once he turns 18, if you file tax returns for him, then it's based upon his income, and he will no doubt get, in return for $1,500, he'll get $4,500. He'll get the $3,500 bond plus automatically without contribution, the $3,500 grant, and without contributions, the $1,000 bond. Can a previously unaware divorced parent challenge the Henson Trust will of a deceased parent in court and obtain the funds? No. Getting a fair number of divorce questions, and I don't know the real numbers, but anecdotally, I think that separation and divorce probably is more common, not the right word, but in situations where there's the added stresses of a child with special needs. Is it difficult to add a sibling not yet 18 to a guardianship later on? Is it costly? It's not that hard. By way of a motion, and yeah, there's some costs involved. I don't know, a few $1,000s perhaps, but less than the guardianship application itself. Okay, so there was a question about an RDSP that was set up when the child was 14, and can the parent remain the account holder when the child turns 18? Well, this again is a question of whether the child is competent or not competent. If the child's not competent, you can stay on as the account holder. If they are competent, then they have to, on the face of it, be the account holder. But if they're competent, then if they sign a power of attorney, which we do a lot of because it's necessary, well, then you can be, as the attorney for property, you can be the account holder. Can my disabled son invest in a TFSA? How does it affect ODSP? TFSA, nothing wrong with them at all. They're just an investment. Yeah. But of course, the TFSA stands for tax-free. Well, the child doesn't pay taxes, so there's no real advantage there at this point, but there's no harm. And the personal asset test is $40,000, so they could have a TFSA up to $40,000. And if they're young, then they may not be able to even put in $40,000. Since of course it's $6,000 a year from age 18. So it depends on the age of the child. The maximum right now, as of this year, is $75,500, but you have to be of an age to do that. Is ODSP impacted by living abroad for a period during the year? Well, on the face of it, you're supposed to notify ODSP if you change your residence after more than 30 days. But the purpose of that is so that you can properly then apply for the same kind of benefits in the province in which you live. But other than that, no. If you're simply going on vacation with your family, you can either simply do it, or if you wish, you can notify ODSP that you're going on vacation with your family and request that they put this on their file and approve it. Then, of course, you're asking for permission. This isn't something that I'm aware of that is somehow monitored. And of course, if you're an individual on ODSP, a couple of scenarios. If you're an individual on ODSP and you want to take a vacation to Nevada, well, we had a client that did that because she suffered from SAD syndrome, depression because of the lack of sunlight. So she had come into a modest inheritance, and she bought herself a camper truck and drove to Nevada and stayed there for 6 months of the year. Well, this is medically prescribed, but it helps to have the prescription in your back pocket. But that's not that hard to get a prescription for sunlight. And then, of course, if the child couldn't remain at home on their own, they have to go with the parents. What are you going to do? Try to leave them at home, pay for a caregiver so you can go off and have a vacation? It's kind of expensive. So, obviously it makes no sense to not be able to take the child with you for your vacation. Can please confirm the monthly income amount an ODSP recipient can earn while working part-time that does not impact their ODSP monthly income support amount? Well, the first 200 is exempt. And then after that, for every dollar you lose 50 cents. And when you get to the point where if the ODSP amount is $11.69, then simplistically, you can see that that's $14,000 a year. And again, simplistically, if the income was $28,000, 2 times 14,000, well, then of course you would have walked yourself past the allowed amount of income. And that's not that bad. If you've got 1,800 hours to work in the year and you make $24,000, that's close to minimum wage, I think. What if my child refuses to give power of attorney? Very common, especially if there's mental health issues involved here. You're stuck. And that happens all the time. Now, you could perhaps bribe them. Sometimes you can wait for that right day. That happens, right? But obviously, if the child's paranoid, the first thing they're going to want to know is, well, why do you want this? What are you going to do with this? You're going to try to put me back in hospital, right? My father has a good pension. My disabled brother and father currently live together, but soon will not due to health issues for both of them. Is my brother entitled to any of my father's pension upon his death? Well, as I said, only if it's a statutory provincial pension. Teachers, municipal employees, hydro generators, power, OPG, workman's comp, WSIB, police, OPP. It has to be a provincial statutory pension. Anything federal is not. There are some private pensions that can pass down to the adult dependent. This is typically if there would have been a pension for a spouse, but the spouse is predeceased or there is no spouse, and the child is the dependent. In that kind of scenario, it could be possible that there might be a pension. I am a high school teacher with the Toronto District School Board. I have no spouse and no dependents. I also have a sister with the Henson Trust in place. I'm able to name my sister as the beneficiary of my pension without my sister losing her ODSP, should I also have a separate Henson Trust, even though my parents currently have one in place? Is there a way to link my will to my parents? Well, there's obviously two questions here. The sister is not an adult dependent survivor. I've never seen that accepted, but I wouldn't hesitate to try. Tell OTIP that, you know, you have a sister, she lives, like, for example, put the story together, you know, that she lives with you, you support her, she's on ODSP, and try to see if there's any survivor pension. I'm not aware that there is, but I don't see why you shouldn't try. Maybe they'll change it, who knows? This is similar to the situation where you have a private pension and no spouse. And then as far as the Henson Trust and your parents' will, well, you could simply leave whatever it is you want to leave to that trust for your sister when your parents predecease you. Why would you want multiple Henson Trusts? Well, I don't specifically want multiple trusts, but if you could have later wills contribute to the original trust, well, yeah, sure, go ahead. Is there any advantage to having multiples versus having one? Well, the usual thing is the residue clause. And it could be the trustees who are appointed. So for example, there's a grandchild with disabilities, the grandparents have a Henson Trust in their will. They would appoint typically the child's parents, the sibling, their child, to be the trustee. They are the parent. Well, all right. Have they built in an alternate that is the same age as the child? Is there one? If they haven't done that, then is there a clause in the trust allowing the remaining trustee to appoint a replacement? And then what happens is typically that grandparent trust would normally, the residue of that trust would go to the parent of the child, because normally it would be their share. But suppose it was some other, substantial trust just for the grandchild. Well, it wouldn't be unusual upon the child's death to have the residue of it distributed among the other grandchildren. Well, if you're the mother, you're going to have the residue of your trust go to your other children, not to all of the grandchildren. And similarly, if there's a trust by some other family member, they might have their own plan that when the child dies, the residue of the trust goes to a charity, for example. So it's usually the residue clause that makes a difference. The old tax advantages to multiple trusts are largely gone now. Does ODSP have the discretionary funds to help pay for creating a will and estate planning? If not, is there agencies that would help? No, there's not. How do you go about setting up an RDSP? Well, you could deal with a bank. They have remote departments that you deal with on the phone, but you'd be better off to go to a financial advisor or have us refer you to one. We have people positioned around the province that serve our clients within about a 2 to 3 hour radius. And of course, it's a lot easier now because it's all remote anyway, right? Zoom meetings. But you'd be better off to have a financial advisor and to set it up either with Edward, with Investors Group, or with Mackenzie Financial through Edward Jones, or any financial advisor group. Because what you need is advice on how to properly invest the money, not just to set it up and sit there and look at the 1,500 generate 4,500 and lose 2% to inflation every year for 40 years. So you need proper investment advice, and I haven't typically found that from the banks. They have a vested interest in you getting the least that you can get, because of course they're investing the RDSP money in other things. So the bigger the spread, the better for the banks. Lots of RDSP questions. Let's scroll down a bit. We've got a lot of questions here. Here's a simple one. Who is eligible for an RDSP? Anyone who is approved for the disability tax credit, and in practice, anybody who's under 49, because if you're over 49, you don't get grants and bonds anymore. Although we do set these up sometimes for people over 49 who have come into a small inheritance, because you can still contribute until age 59. You don't get grants and bonds, but you can exempt the asset in the simplistic way by contributing it to the RDSP. I have to go as my autistic son is needing me. I understand. Will I still receive the link to watch this later? Yes, you will. Every registrant today and tomorrow at noon. And you could watch it again at noon tomorrow if you want to. Just go back to the invite and register again. We'll receive this recorded video and the PowerPoint slides. Who is eligible and what defines the benefit for the Canadian caregiver benefit? Well, the caregiver tax credit, and it's now called the family caregiver, and the line that it's used on has varied over the last 5 or 6 years several times. But as of 2017, it's on line 30425 or 30450. Prior to that, it was 307, and prior to that, it was 315. But if you are a caregiver for someone over 18, family member, and you pay taxes, income tax, then up until 2017, the child had to reside with you. But in 2017, they removed the reside with criteria. So even though they don't live with you, you're still the caregiver. At that time, up until 2017, they had to reside with you. You know, you couldn't even live with them. But, and the neat thing about this is, I'll show you some numbers here. You see here, this is borders, room and borders, 48,233. You see that? Well, there's 378,000 people on ODSP in Ontario as of February 2020. And of them, only about 14%, 48,000, were living with family, typically parents. So at that time, up until 2017, the child had to reside with you for you to use the caregiver credit. Now, it reduces taxes currently by about $1,000 a year. But until 2017, only that 14% could use it. So then they removed the reside with criteria. And what that means is that in almost all cases, not all, of course, in some cases, you know, parents, family members are in fact not caregivers. It happens, right? There are instances, many, I guess, but not 378,000. So what this means is that all of those families that previously, the 378,000 minus 48,000, the 330,000 would not have qualified for the caregiver credit. And now another 330,000 households potentially qualify for $1,000 a year. This is big. That's a lot of money. 330,000 times 1,000. Now we only have about 5 minutes left. I see we still have 213. We started with 235. So that's pretty good. So we'll see how many more, but this is essentially the last few questions. So if you have questions in future, you could ask Victoria or Karen about the disability credit and caregiver. Specifically, you could ask Karen about benefit increases. Diane, you can ask her anything. She knows everything. But besides that, you can specifically ask her about legal guardianship. Jennifer could answer questions about wills and Henson Trusts. And then, of course, you could address things to me as well. The simplest way to start the process is to go to my website, and you'll find that there's various places to click to do a family evaluation or family details. And if you're in doubt, just go to the contact button on the top right, and the drop-down links will have family evaluation. And you fill in the form, tell us the story. And it comes both to myself and Karen automatically, and we review it. We give you a reply, an initial assessment. Isn't that right, Karen?
Yes. So I tried my best to answer as many questions as I can. Most people had a lot of ODSP questions and some Henson Trust questions. So I think it's best if they just email us and we can answer the questions or set them up with at least an email or telephone consult.
Probably the simplest, yeah.
Absolutely.
I mean, we'll see if there's any particularly interesting questions. You know, we'll maybe try to reply to them, but we will be doing another one of these this year. And as I mentioned, we'll be doing specific ones on several topics: wills and trusts, caregiver and disability credits, ODSP increases, guardianship, which will allow people to focus on the thing that they're most interested in. There's so many things, you have to just start someplace, you know. I think that's all the questions. We must have answered a whole lot of them. And that said, I'd like to thank everyone for taking part. There's 203. I think it's time to let everybody go and have a cup of tea and sit back and relax. And we look forward to doing this again tomorrow at noon. Thank you very much.
Have a good night.
Good night.